print, email, Facebook, Twitter. More. Westpac engaged in unconscionable conduct but failed to rig BBSW interest rate. Court finds. Despite being found to have acted unconscionably, Westpac has scored a number of legal victories after splitting from the other big banks and defending ASIC's accusations of rate rigging. The federal court found Westpac had engaged in unconscionable conduct and breached the ASIC Act by attempting to manipulate the bank bill swap rate, BBSW, on 4 separate occasions. The court also found Westpac had breached its financial services licensee obligations through inadequate procedures and training for its traders. However, Justice Jonathan Beach found the Australian Securities and Investments Commission had not made out its case against Westpac for breaching the Corporations Act provisions against market manipulation or market rigging. Justice Beach said, while Westpac traded with a dominant purpose of influencing the BBSW on 4 occasions in 2010, ASIC did not prove these were contraventions of the Corporations Act. I am not satisfied that the holding of the relevant dominant purpose on the said 4 occasions, together with the other evidence, establishes the effect or likely effect of creating or maintaining an artificial price for or under such derivative instruments, Justice Beach wrote in his judgment. I likewise do not consider that establishing such a purpose for trading in prime bank bills establishes a false or misleading appearance with respect to the market's in or price for trading of such derivative instruments. In other words, Westpac attempted to influence the BBSW but did not succeed. The BBSW is the key benchmark interest rate in Australian financial markets, set daily by a panel of banks and used to price billions of dollars worth of financial products from complicated financial derivatives through to home loans and credit card rates. ASIC welcomes judgment. Justice Beach noted many of the internal bank communications. ASIC based its case on were open to competing interpretations and ASIC bears the onus of proof given the gravity of the allegations. Accordingly, where there has been uncertainty as to what was said or what was meant or conveyed after considering the context and all relevant circumstances, I have resolved that uncertainty in Westpac's favor, he explained. In its initial reaction, ASIC said it welcomed the judgment. This is a very significant and positive outcome for the integrity of Australia's financial markets, the regulator noted. However, corporate law expert Associate Professor Juliet Overland from the University of Sydney Business School said both parties had wins and losses. At the moment, particularly with the level of scrutiny resulting from the Banking Royal Commission and the resulting focus on ASIC's scrutiny in this area, I don't think either of them have come out as true winners from today, she told the ABC. The difficulty there is essentially one of proof and one of satisfying the very difficult legal tests. And that is where ASIC was unsuccessful. Unlike its commercial rivals, Westpac took the gamble of defending the rate rigging case in court. NAB and ANZ settled with ASIC for $50 million late last year, while CBA, facing fewer charges, settled for $25 million earlier this month. In approving the NAB and ANZ settlement, Federal Court Judge Jane Jaggett said the public would be shocked, dismayed and disgusted by the behavior of the banks. NAB and ANZ have admitted to manipulating the bank bill swap rate to their advantage and the disadvantage of others and thereby admitted to unconscionable conduct, Justice Jaggett told the banks. Westpac waiting on the bill. Whether Westpac's go-it-alone stance is vindicated may be known within the next 2 weeks when the hearing will resume and any penalties arising will be considered. The maximum penalty for 3 of the 4 counts of unconscionable conduct is $1.1 million. One count occurred in the days when there was no penalty for unconscionable conduct, while a maximum fine of $3.3 million looks like Westpac got off lightly. It could still be forced to pay ASIC's legal costs and the costs of the investigation. Those costs are yet to be determined, but in the ANZ and NAB cases, investigation costs amounted to around $20 million, while Westpac faced fewer charges, lessening investigation costs. The legal bill will be substantially higher than those paid by the other banks which settled on the steps of the court. Justice Beach reserved making an order on costs until the hearing resumes. However, Associate Professor Overland is anticipating a negotiated penalty settlement. Given the current environment, once again because of the Banking Royal Commission and scrutiny over ASIC's performance, it would be in both parties' interests if they can agree on a negotiated settlement to put before the court for approval, she said. I would be expecting that we would be unlikely to see an appeal here. I would expect that both would like to claim this and continue to claim this as a win. In a brief statement, Westpac said it was committed to working with regulators in a constructive manner, including when we have a genuine difference of opinion. When that occurs, our aim is to resolve the difference in an open, transparent and respectful way. New penalties too late hit the bank's ASIC's pursuit of the big banks, and the difficulty in pursuing charges of market manipulation has caused a major rewriting of the law. Privately, ASIC makes the point the case was always about proving misconduct by one of Australia's largest financial institutions, rather than the impact of any rate rigging. The manipulation of interest rate benchmarks and the impact on prices was always inherently more difficult to prove than more straightforward manipulation of such things as front-running and insider trading on the stock exchange. However, new laws passed last month significantly lower the hurdles ASIC will have to clear to prove future cases. The penalties that can be imposed are significantly harsher. The maximum fine will now be $8 million with an additional impost of 3 times benefit gained from the manipulation. If that can't be worked out, a penalty of 10% of annual turnover could be levied, which in Westpac's case could have been in the order of $2 billion. Print, email, Facebook, Twitter.